No, that's wrong podcast.
We just lost half of our audience.
I think I did lose part of the audience. Actually, the reason I started off that way is because I wanted to make a point. And the point is that if we were watching a sporting event and maybe women's indoor volleyball, would that viewing of that particular sporting event constitute sensitive personal information? The fact that we were watching a women's sporting event, would someone be able to infer from that information that we were a particular type of people, and would that potentially be sensitive information now or in the future? I think that's interesting because this is an event about sensitive personal information. I want to welcome you to episode 17 of Your Bites, Your Rights, which is getting kicked off right now. And I've lost my notes here. Your Bites, Your Rights is a live weekly discussion and podcast about ownership, digital rights, and your privacy. And I'm here today with my co-host and partner, Christian Camille, managing partner at Sustany Capital, a VC investment fund that focuses on blockchain. Chris has been doing some phenomenal work on the future of money and the understanding and the problems of central bank digital currencies. Say hello, Chris.
Hey, money is a solved problem that's not evenly distributed yet from a technical level. And so, yeah, what we're really working on and building the web for the first time, that's what I'm in the space for, and what we're probably going to be working on for the next 20 years. So whatever you're using now, it's not the World Wide Web. It's the commercial web. You're talking to Google. You're a non-player character in a game called Google. And that has been bothering me at least since 2008. And so that's what we're trying to fix. So that's why I collaborate with Jeff and a lot of other folks to chip away at the idea that we should be games in whatever game that a commercial company sets up whenever we interact with technology and their specific digitally network technology, because that is potentially the most important technology for us to actually have a viable future as a species, because it's human coordination technology. But unfortunately, we have let it divulge to what you see now, which is companies selling social engineering as a service, which, if you have listened to that before, you've heard me say that before. Back to Jeff, back to the studio.
Thanks, Chris. Well, what we want to talk about today in this episode is sensitive information. And over the last weekend, I did a post about sensitive information and the taxonomy thereof. And I did a little bit of research. It actually didn't take me very long. But what I did is I compared the sensitive information that is regulated in 20 different laws across the globe. And when I started to do that comparison, I realized that it was really sort of hard to enumerate those pieces of information because people have sort of different definitions. But I managed to do so. And when I started to sort of add up those different pieces, definitions, and count them, I realized that there was quite a bit of discrepancy. That there are certain types of sensitive information that most countries regulate, like religion and health information and race and ethnicity. But then there are other pieces of information that aren't regulated across the board, like genetic information and biometric information and location information, though those pieces of information are becoming more and more regulated now in newer pieces of privacy legislation. But culturally, there's a lot of difference in the pieces of information that are regulated, such that in Kenya, marital status is considered sensitive information. In Saudi Arabia, tribal origin is considered sensitive information. In Turkey, clothing is considered sensitive information.
Did you say clothing?
Yeah, clothing. Isn't that weird or interesting?
Like you cannot disclose what you're wearing?
Apparently, right? Because it determines your caste, right? Your social status. It's very important to them.
Okay. So no one tell people that what my T-shirt says, please. Okay.
Right. But the point is that, as we're trying to control the data flows across the world, this is going to make a big difference, Chris. It's gonna if companies are actually concerned about how they control sensitive information and what they do with sensitive information, it's going to be more and more complicated as regulations control not just personal information, but sensitive personal information, because sensitive information is not regulated just by saying, oh, hey, you've got to get consent, or you have to have consent and you have to do X, Y, and Z. But sensitive information, you actually have to, in most cases, have affirmative consent. You have to get people to actually say, yes, right, you can use my information. It's not an opt-out, it's an opt-in, which is a much higher standard to be able to use that sensitive information. So, in order to talk more about this issue, we've brought a couple of experts in, and we're going to bring in a couple more in later on. First, here we've got Dazza Greenwood, and Dazza is, sorry, I'm pulling my notes up here, is the founder of civics.com, a boutique provider of professional consultancy services for legal technologies, automated transactions, data management, and technology strategy. And he's also a researcher at the MIT Media Lab, where he's advancing the field of computational law and building out law.mit.edu's research portfolio. And I think he's going to talk mostly about sensitive data in relationship to the Data Rights Protocol, which is one of my favorite projects, and in relationship to structured data as parts of computational contracts. So welcome, Dazza.
Oh, thank you so much, Jeff. It's great to be on this podcast, and it's so great that I should just start by saying, long-time listener, first-time caller, panelist, and it's so great that there is such a forum for a continued discussion and exploration of this thread of topics around personal data and data rights. And I was particularly intrigued to see your LinkedIn post recently of the taxonomy of definitions for sensitive data that you pulled out of statutes and I think other legal rules from around the world. Many of those I had never seen before or heard of. I mostly am focused in the United States, a little bit in Europe, and just whatever comes across my plate from the rest of the world. And it really was a stark reminder of how context sensitive these definitions are, and how they are really a reflection of the societies and the sort of almost facts and circumstances arising from the legal rules within which these definitions exist, which is kind of a pickle if what you're looking for is a standard, know what it means and how to operate it at a glance kind of definition. This is one of those what I would call slippery areas of law, which can be hard to engineer around because the same words mean different things, and sometimes different words mean the same thing, and every other combination of that kind of semantic puzzle. But starting to look at these definitions and put them in something like a matrix or a spreadsheet is a critical first step to getting our mind around the dimensions of this facet of law. And for me, when I look at this, I always think in terms of what I would call legal engineering, and how to take legal rules and almost sort of cross-tabulate them to technical requirements for systems, so that, for example, when someone clicks a button to get access to their data, it can just happen automatically, and yet, in the back end, all of the functions and roles and flows and approval chains are happening in ways that completely track to the applicable law and hopefully conform to people's expectations. And so, putting these things on a matrix is really the first step to starting a conversation on surfacing requirements and making a kind of almost a design tablet from which we can start to crosswalk between how systems work and what the law is. So I guess my opener is just I'm glad that you finally got us to the beginning of a like a tabularized way to look at these definitions, so that now we can, in a sense, begin to grapple with them and also grapple with how they come up. Like why and when and to whom is it relevant that certain information is sensitive, because that'll also tell us a lot more about whether it matters that like it may be very, very good, in fact, that some of these definitions vary so much, because that's the result that we would want. So then I guess the question is, how do we come to think about this, and then what do we do in the face of these different definitions, like with the standards that we're creating, with the technologies that we're configuring, with our guidance to consumers and to businesses alike in terms of how to comply with and to execute on these rules. So those are some opening thoughts, and I'd like to hand it back to you.
Yeah, Dazza, you just put the biggest smile on my face, because the term legal engineering is a term that I've been using for a long time. And after our last Your Bytes, Your Rights show last Friday, actually I did a 2-hour meeting with the Chief Innovation Office of University California, Irvine here, to establish exactly that. So it's a 2-year effort. It's just going to start with me teaching a class at the law school, introduction to basically blockchain. That's what we're going to call it. But for me, blockchain is just one example of a decentralized software solution and mapped cryptographic primitives. I don't want to get too nerdy about this from a technology perspective, but the largest point here is really that we created these artificial disciplines of engineering and law, and we need to really bridge those, right? Because engineers don't understand the law by and large, and lawyers don't understand the state of technology and technology by and large. And we started putting these definitions onto GitHub some time ago now, so that engineers just can take that, because Jeff and I talk about this a couple times a week, that engineers kind of invent new terminology, not realizing that if, when, where you're doing this, then whatever your solution does, it doesn't actually, it can't actually be integrated with real world economic activity, because your definition of authentication, verification, certification actually is not what the legacy fiat system requires for you to enforce your rights in meat space. Anyway, so let's put a pin on that. Let's have a separate discussion about that, so that we stay topical here, but needed to share my excitement.
Yeah, I thought that was interesting. Dazza, when I think about this sort of taxonomy, a couple of thoughts came to my mind. One is, if a company is trying to be ethical and think about applying that kind of a taxonomy, one thing they might want to do is sort of do some geocoding, so that if somebody's trying to enforce their rights from a particular country, they could make sure that they were being culturally sensitive, and make sure that they get that right, so that get it right, so that they were accessing the correct data fields based upon a particular country. And it makes it a little bit easier if you've got this kind of a taxonomy set up. But also, if a country is trying to make sort of a broader, take a broader approach and apply the most sort of grand standard, and just wants to have a global standard rather than a country by country standard, they could look, at taking that to a higher level and trying to take all of those fields up, so that everybody sort of has the same right. But if you start to take every piece of information that somebody thinks is sensitive, where does that eventually take you? Does Does every piece of data eventually become sensitive to someone? I mean, maybe it does. And is that a good thing or a bad thing? Perhaps it's a good thing from a privacy advocacy standpoint.
Yeah, so true. And just to pull on that thread a little further, it with the same people in the same circumstances in the same jurisdiction, the same datum could be, not sensitive on Tuesday, and on Wednesday could be extremely sensitive because circumstances have changed in some way. And then obviously, if we want to make this almost intractable, when seen in combination with certain other bits of information, it could become highly sensitive. So this, to some extent, it's kind of a losing game to try to maybe, let me put it another way, maybe what we shouldn't be looking for as the ultimate outcome of the exercise of talking about these definitions is having a global definition, because what I was sort of getting to earlier is this is very context sensitive, and maybe that's not bad. Maybe the question is, how do we surface the context so people know what to expect in a given set of circumstances, and it can, and that we can be a little bit more fluid with responding to and adapting to the circumstances that matter at that time. I mean, that's a lot harder to engineer than saying, like, this number is always sensitive and that piece of information about you is never sensitive, but it may be closer to the outcomes that we would need.
Yeah, well, and privacy advocates that commented on the post that I made last weekend were quick to point out that it's not just individual pieces of data, but data in combination, right? And a lot of the statutes outright say that some information is sensitive only, when in combination. I think one example put out there is that subscriptions to a magazine, for instance, might be sensitive if it's a particular type of magazine. So, for instance, if you're subscribing to a magazine that's primarily for a gay audience, perhaps that is sensitive information in certain hands. So and the same thing might be true in certain instances, as we started the show off with watching women's volleyball. I mean, maybe in some context that's sensitive information. So how do we use such a taxonomy if there are all kinds of other combinations of data that also then become sensitive?
Indeed. It reminds me when I started my career, I was an attorney in a state government. And one of the things we did in the 90s, I'm sure it's more sophisticated now, but there would be certain people in certain very difficult circumstances where basically our Department of Motor Vehicles, Registry of Motor Vehicles, it was called in Massachusetts, would need to basically come up with completely different identities for these people. And then we would have an address on their state-issued driver's license and other things where state agents would gather the mail and get it to that person at a completely different undisclosed place under a different name. Those types of more extreme circumstances where we're protecting people, the same data that I would have in a white pages, where I would on Tuesday again, like what do I expect people to do? Well, they want to call me up on the phone to sell me something or to set up a barbecue. They're doing a lookup, let's say in like an LDAP service, if it was not paper but it was electronic, to find my telephone number or email address. Totally benign, not sensitive. In fact, it's published in the white pages, as a public utility. But on Thursday, I'm in witness protection or one of these other variations that we would support, and we would want to definitely know who is looking for the home address of this person, and that might actually launch an entire investigation. Very sensitive, in other words. So I just can't stress enough how context. I'm describing an extreme example, but there's gradations up and down every axis in terms of sensitivity from the perspective of the person and the person that's acting to find the data and what their intentions are and everything in between.
Let's bring Mark McElhaw. I'm probably pronouncing that in a bastardized way. Mark is an experienced strategist and an active member of the research ops community. And he wants to talk about research ops. I want to hear about that, and maybe also consent frameworks and a little bit about data ownership. I'd like to get into that with Mark. Mark, what do you have to say about this topic?
Well, I'm really glad to be part of this and hear the conversation so far, because so for me as a researcher strategist, it's all about context. And one of the projects, so I got involved with this because I saw your wonderful post about the PII diversity, and I was going, wow, this is great, because it ties in with a project I've been working on with this community called the Research Ops Community, which has kind of grown from 2,000 to 12,000 in like 3-4 years. It's an international group of researchers and research operatives. And one of the programs has been research repositories or knowledge management systems. And so what we've been doing, there's been a few strands of those, like we've created a consent form builder because of the complexity around it, but also we're working on a taxonomy. And we made the rookie mistake of going really big, which is the post that I gave you. It's a work in progress because we're a voluntary community. But
it was pretty huge.
ambitious, wildly ambitious for being unpaid, I think. But that definition is the thing that, so I've been talking to librarians and archivists, and so I've been learning the importance of definitions. And like research doesn't have definitions, like insight, we don't have a standard definition for. It's really strange, actually. It's an irony. But we looked at sensitive personal information. And we've also come up with a PII table, which is literally, I think it's 715 entries from around the world. And that was because we realized that when you're doing consent, you have to make sure you get the consent right for the country that you're working in. So when you're building a consent form, you need to make sure the form is compliant with the organization or the people that you're actually talking to, for the participants, when you're doing your studies. No one's really looked into it. So when I saw your piece, I was going, this is wonderful. I didn't even know this stuff. So it sort of segues with stuff that we've been looking at. But I guess one of the things that's really interesting is personal information. I really like what's been said, Dazza, what you said about context. That's a really big thing. And I worked for a large organization where we were looking at identity, and they wanted to do an online community that pulled all of their different stables together. So one would be dating, one would be news, one would be cars, one would be, you name it, literally all these magazines, as you were saying, magazine subscriptions. But the trouble is that typesetter 123 would not be having the same identity as Hot Lips, whatever. Do you see what I mean? So the things that we ourselves are switching identities by role. So business and personal is a classic one, and that's just a very straightforward one. So when we're talking about sensitive personal information, I love the fact that we're looking across countries, because we want to find something that's interoperable, between not just so it's countries, regions, communities, and I think that's where the publication idea comes in, is how do you make it interoperable so you're not disclosing something that is inappropriate, but also it could be illegal in the country that of the app that you're doing. And you mentioned LGBT community, and I know that one of the apps, the dating apps or the hookup apps, they've switched countries to Russia and China, and so therefore there have been questions around that. So it's a fascination of problems and opportunities that I'd love to see. And I think I'd finish with, I think the one thing I learned from consent, which I think is where this then ties in, is how you opt in and opt out, and how we move into this thing called fluid consent, where you can change. It's not that you can withdraw consent, but also you can determine, to me, I see it like as a distribution license. So you work out what information I am going to deem sensitive in this context. And we're not there yet. And it's really interesting.
Yeah, and there's the whole meta language that we have thus far very poorly developed. So you were touching on a couple of concepts there, right? So a lot of people will use the term profile kind of indiscretionary over a group of data. And so we're trying to define this somewhat more narrowly, as in a persona is the data that you control about yourself, but then a profile is that data plus whatever the platform that you're engaging with has on you, because comes back to they profile you. That's kind of the background there. I'm targeting you with whatever information I want you to see because you're engaging with my particular technology, with my particular service. But we kind of need to start there, and we look at this from the perspective of having kind of concentric rings about yourself, around yourself that you control, and if and when and where there's kind of intersections or encroachment on those, then you need to define what are the legal requirements, i.e. is there particular thing that I'm doing, does this require a government issued credential, for example, right? So I want to engage with a certain service that the government offers, and I need a government issued credential for that, and that could be because I'm boarding a plane or I enter a government building. But what we've done, unfortunately, in the past, because mostly of the limitations of legacy technologies, we kind of have abused and overused these technologies, i.e. your driver's license have, in the United States at least, has become this universal tool to access all these particular data silos. And now, as a consequence, there is thousands of entities that have copies of that data and that particular instrument. So it's no longer yours in that sense. And so the metaphor that I kind of always bounce off engineers in that perspective is, well, think about your technology from the perspective of, if we never had invented digital technologies, if we have never invented databases, how would you approach that? So you would have a physical thing that's your government issued credential, and you would use it in a particular way. And the beauty about this particular passport or physical driver's licenses before the invention of digital technologies, you have it in your possession. You have it under your control. So you go home, put it in your drawer. So for someone else to do something nefarious with that, they have to find you, break into your house, take it from you, make a copy or whatever. And so that's the metaphor that I keep offering engineers specifically to think in these terms, because, and then I stop my usual rants here, because what we actually discovered, and that's really the invention of the Bitcoin white paper, is that we can have property rights in digital space, right? So that's the primitive that we introduced with decentralized software solutions, blockchain being the most visible example. I have property rights. I have sole control over a set of bytes that I can either make available or invisible or transfer. So, and ultimately, that's kind of the big picture that we mapped out over a decade ago. We basically need to reverse the paradigm that we implemented. So we implemented this push paradigm. So whenever you interact with digital technology, it's pushing things on you, rather than a pull paradigm where you selectively give access to whatever you actually should be controlling. And I call it all your digital dust. You should have ownership and possession and control over all your digital dust.
Right.
And yeah, so you'll find me ranting about these topics on and off for decades.
It's a super interesting take you just put that surfaces another issue, I think, which is the notion of property, and the fact that digital is an embodied extension of our own property, and the way that we think of property and our own personal property. And so the thing is that when you talked about companies taking something that not being yours anymore, is I read an amazing article on informed consent by Anya Kovacs, taking this feminist perspective of ownership and going back to the fact that we ultimately need to take ownership of this. So that's a really key thing. And I know it's been used in zero party data is, I think, the concept. I think Citizen Me is running that, where you own the data yourself, and it's not, you then decide how you're going to distribute it. But it seems to be early days on that, from what I know.
Yeah, for sure. Because, really, in essence, we already touched on that. It's impossible to manage data under the current distributed laws in the world, right? They are conflicting with each other. And it's kind of like the tax law. You can't actually comply with the tax law because it's conflicting with itself and to some extent. But when it comes to data rights, and I'm always kind of hesitating before even using this word, I think these words don't really go together, right? So as a human, my starting point is always the same. As a human, I have the unalienable right not to be observed. That's my starting point. And everything else afterwards, you need to legitimize that. So you basically like need to have a warrant to keep a copy of any of my data.
There is oh, sorry.
Go ahead, Dazza.
I was just going to say, going back to this question of the relationship between personal data, data rights, or just rights of individuals, and property for a moment. I know it's very, I have to just start by saying I'm aware it's controversial, especially in civil liberties circles and certain consumer advocacy circles. I think they're appropriately cautious of reducing personal data rights to property law alone, because in there are also rights that arise from civil liberties, and all privacy and human rights do not sound in property. Some of them need to be inalienable, universal, etc. Nonetheless, having with that disclaimer, fig leaf, let's take a look at property law, because it's not all bad, and some of it is a reasonable fit, not to the exclusion of other sources of rights, but maybe in certain circumstances it's not a bad fit. So one of the things where I think it's an interesting fit in the United States context is going right back to some of the original amendments to the U.S. Constitution. We have a concept that sounds in privacy for our protections against unreasonable search and seizure. And if you parse the language, one clause of that that's really not been litigated or talked about for decades, many decades, is people have a right to be secure in their papers and effects. And so I spent a lot of my early career making the case, I think ultimately successfully, that when the law says paper, we can deem it outside of very specific circumstances to include electronic files and documents, okay? Like the legislature wasn't saying this medium, they were talking about the record.
Right.
Okay, and the Uniform Electronic Transactions Act and a bunch of other areas of law, make that very explicit. So what are papers that we have a right to be secured, and what are our effects? Papers may be, data in the form of records that are personal. It's our personal data. And that would be the equivalent of having it like on our person, like in our pockets. What would that be? Our C drive, or it would be in a secure enclave, certainly. And then what are the effects? Maybe that's like snippets of code, or or other types of things. Maybe that aren't like narrative files. Maybe they're images and video and applications, perhaps, or there's some. But I think there's a direct line we can trace between the concept of being secure in our papers and effects, and secure in our personal data. That emanates from us, or that's within some zone or penumbra of ownership and control. And part of what's cool about this is, like, some of my papers, like if I had a diary and it was like in my pocket, and I was like kind of unreasonably searched by a police officer who seized my diary, this on the one hand would absolutely fit under this like civil liberty of unreasonable search and seizure, and it's a privacy violation, literally, like canonically in law school that would be a privacy violation. Like let's say like that afternoon or that morning, I took that diary, which had some nice gold and gray and blazing, and had like some good stuff for like a recitation of events or doodles, and I sold it on eBay no problem. No one would blink an eye. I'm entitled to sell my diary as property on eBay. It may have an independent legal framework that also talks about the roles and the rights and obligations of people. And all of it at the end of the day looks at like people own, the relationship between a person and a person's property is not terrible in terms of the outcomes that we would want. Like you said, you have a right to not be observed. If you have property, you've got the right to have no one observe that property. You know, you've got all rights to own and control every facet of the property when you have complete, fee simple total title to that property. No one can look at it, no one can touch it, no one can borrow it. There's certain parallels here. So I like this thread that you were bringing up in terms of property, and we can't over rely on it, especially not exclusively to civil liberties and human rights. But I do think that we can yield some good juice from property to get the right outcomes legally for personal data.
Yeah, the thing is we need to extend it, right? Because and we talked about this on a prior episode. So there is this idea that you can seize things that are in plain view. So we talked about the fact that there was a judgment recently towards a data scraper where the court decided, because it was in plain view, because it was accessible and public, that particular entity had actually the right to just grab it, in this case from LinkedIn, and store it for themselves, which I'm kind of torn about that. On one hand, I don't like the idea that LinkedIn has rights to that, but also I don't like the idea that someone could just scrape it, copy paste it, and now they also have a copy of that. So in my mind, I own all the data on there, and unless you have my permission, you don't get to have a copy, regardless if I consented to whatever ideas you introduced with your terms and conditions that by and large I would think are irrelevant, really, right? So I taught privacy law right after law school. I was like in the mid-90s. And in Europe, these concepts are much further developed. It's, I would say, about a decade ahead of the United States in thinking. But a lot of the things that we tolerate here would be utterly unlawful already in that jurisdiction. And from an investor's perspective, we are investors in this space. I just look at these solutions as being simply not viable. So Jeff aggregated this very deep database of data brokers, and I call it a target list. So we want to really invalidate all of these businesses, but in a way of creating new businesses that make it a business model to invalidate these legacy businesses, which includes the Facebooks of the world, which includes the Experience of the world, and any data broker, including what I call like the bottom feeders, the low-hanging fruit, the people search companies, which are, in my mind, the worst of them all.
I want to introduce Michael Thoreson here, or actually let him introduce himself. But I want to also talk a little bit about data ownership and my sort of thoughts on that too. Let's let Michael introduce himself first, and then we'll try to get into that. Can you turn yourself on, Michael, or are you blanked out? Maybe I'll talk about ownership while we try to figure that out. Oh, it says host stopped video. You might have to enable him, Chris.
Did I mess something up again? Okay, make co-host. Yes, Michael, you are now a co-host. There you go.
Woot! I am now free. You may regret that decision. I may dominate the show. I too like to rant, and brevity is not my strong point, so I will try to be as concise and brief as possible. But the discussion so far has given me a lot of things to ponder and respond to as well, in addition to my own thoughts of this personal information aspect. It's a very sensitive topic and also a very passionate topic for me, since I am a victim of not only identity theft once, but twice, as a result of data breaches from both corporate and government entities. So there's multiple versions of me out there, but I can, show you I am me here. The women's sports thing you opened up with kind of was interesting, because when I think back to when I managed restaurants, if someone was stealing cash, the only way you'd really be able to figure out who stole it is if you had repetition, which would then create patterns. So a singular event of, oh, we're watching women's sports, may be an issue, privacy data issue, or may glean something or whatnot. Being a singular issue might be subjective. If every time was a women's sports thing, then now it's a little more objective and you can now claim a lot more from it. So I found that kind of an interesting thing there. This also talk about basically no silos for data. That was also very interesting. Engineering, or the engineering of principles and such. I try to take more of a with my company Crate that I've started up, we're evolving how the world creates, consumes, shares data. And we're looking more at a more fundamental level in that the person themselves should own their data, which has been touched on here as well. And regulation is having an issue because they're coming from the perspective of the third parties. So the stakeholders in a lot of these regulations are the collector, the controller, and such. Sorry, there was the third one, collector, controller. I'll probably remember it after the show.
Processor, subject.
There was three stakeholders that we had identified with our legal counsel that seemed to be kind of a broad spectrum here, and it was called collector, controller. Anyway, it's not a big matter. The one that was missing was the person themselves, and some of you touched on data being property and ownership of the property, but I don't think it's very well defined because there's no clear definition of like when does the ownership of that data begin. When you're talking about property, it's I have ownership of property when I buy it, or when I say I'm a manufacturer, I produce something. I have the ownership of that property up until say I sell said property that I've manufactured. So if we look at data of if it's my data that I've created or data that's attached to me as a person, that's my property until such time as I decide to sell it. Regulations coming from the standpoint of, well, these entities have your data, so now we need to establish what your rights are. Well, they're with your data. I think regulation and technology needs to take the perspective of it's my data, I own it, and we now need to establish what the rights are of people that have it, either given from consent or from me selling it to them or something like that. There needs to be a paradigm shift there. A close analogy to that is Mother Teresa refused to ever go to an event or be part of anything where it was anti-war. She always said, if you want me to speak or to be part of something, it needs to be pro-peace, right? So she was always coming from the perspective of, take the perspective that you want. So if you want people to have more rights over their data, have regulation and technology that establishes those rights from the get-go, and then your legislation or anything after that would be for, now what happens when that information is given to a third party? So kind of a change in perspective, which I think would make a lot of this stuff easier.
So hold for a sec, Michael. I think you're raising a really good point here about ownership and how we think about it, about when those rights accrue, and how, to some extent, how ownership is designed. And that's actually what I wanted to sort of talk about. So I think you're onto something important. But let's step back for a second and sort of talk about how ownership gets designed around data, because I don't think a lot of people think about this. But if you consider your personal data that's owned by a company, let's say that the data that Google has about you, you can think about that data in different types of buckets. And there's actually a lot of buckets, but let's just talk about a couple, right? There's the data that you specifically give to Google, right? That you fill it out in a form and give to them. There's the data that they collect about your actions. So stuff that you do on Google that they collect about you. There's the data that they infer about you from the things that you do online, right? right? There's also data that they collect from other sources, internal and external, about you that they then add to your profile, right? And then there's all kinds of other buckets as well. But if we just take those 4 buckets, each of those buckets, they actually have different legal rights to, depending upon what types of legislation might affect them. So if you look at, I can't actually point to specific laws, but in some laws, right, the information that you give directly to Google, you have much more ownership right of. If they infer that data about you, right, you have less rights to that. In fact, if you have like a data subject access request, right, you may not be able to get that information. If you have a delete request, you may not be able to delete that information. Some places you might, other laws you may not, right? So right now, legislation and lobbying efforts and different things like that are affecting the ownership design of your personal information.
Right.
And that's actually a little bit scary, right? So what actually is the definition of our personal information, and how much of it do we own?
With those buckets, you end up with a conundrum if you're looking for a singular owner. If you're looking for joint owners, yes, Google can infer information about me by me using their services, but it's my actions that allows them to create the data for them to get that inference. So I would argue that in that case, it's a joint ownership, just like you have joint ownership of houses, lands, businesses.
And then what happens to that data? So if I take that same piece of data and I have it in a Google database that's hidden, does it have one legality? And then if I put it on a LinkedIn profile so that everybody can see it, does it change its ownership principle so that somebody can now scrape it and it's no longer my data? It's now public information.
Yeah,
if the government takes it and puts it in a database, is it now public information?
Yeah, and I would say you cannot actually sell it at all. You can't actually have ownership over someone else's data. You can have a limited license, but you should always be in a position to just unilaterally remove that license, right?
Right. If it's your data, but then you sell it, is it now public information? Is it now no longer yours? Or is it always yours?
I mean, that's a long discussion, but by default, I would take the position that we're getting down into organ territory, as in, should we allow people to sell their organs? Right? Yeah, you know what I mean? It's like, is that permissible under the law? And maybe that's not a good idea, and like my gut tells me it's not a good idea.
This is the exact issue.
Yeah, my gut tells me not to sell my gut. Yeah.
About property now.
We could maybe make a little progress on this by recognizing that there's something that we want to call identity, individual human identity. And online, for better or worse, that expresses itself digitally, you know, whatever the system is, whether it's, you know, through a directory service or a decentralized identifier or whatever it is, it's digital. That data, I'd say broadly, is inside probably in the bullseye of personal data, and yet it's also identity. And I think when we get into that inner sanctum of personal data, when we'd say it is the operational functional identity that we communicate and act through, that we're addressable at, etc., that represents who we are as an agent, that's when we get into the inalienable, you know, can't sell it, you know, kind of human rights stuff. And then it's important to distinguish your functional identity from the stuff that you own, that we ascribe ownership rights to your identity, like my files and my papers and my whatever.
Yeah. So
that's a good distinction. I like that.
Yeah. So Gaza, even though that I chair the banking and finance SIG at the Decentralized Identity Foundation, I'm actually trying to take that word out of the vocabulary in our context entirely, because for me, identity requires consciousness. And that's what we're not talking about, right? That's a kind of an entirely different discipline that's trying to make progress on that. So the threshold is really a different one. So I think by and large we're talking about network technology and digital technologies at the moment for the time being, and so in that context and legal concepts in that context. So from a legal concept, and I'm interested in hearing everybody's opinion about that, what we're really talking about is kind of this agency attribution layer, as in, did someone affect a certain outcome using digital technologies, and if so, can I attribute this outcome to him, right? So it's kind of the difference between, while I was using a car, I was using a technology, and there's a decision to be made whether or not I drove over this person purposefully and killed him, and I'm gonna be charged with murder or manslaughter, or I was just being distracted and I hit him by accident, right? Because the larger point here is, so now we're getting to this point where digital technologies is so deeply ingrained in physical outcomes that you need to be able to make that distinction. I would argue that agency is breached by the effects that Google, Facebook, and otherwise social engineering as a service solutions providers offer to their clients, because I think we can at some point in time establish that certain actions would have not been taken if these technologies weren't being made available. And that could be something trivial, as in I bought something useless because I was kind of social engineered into that, because the platform that I was engaging with made 21,000 data points available to that quote-unquote advertiser. But the result could also be something else, obviously, because the seller, the technology provider, doesn't really care about the outcome, right? They don't care if you're buying something, if you're not doing something, i.e. not voting, or you start to believe something entirely nonsensical and drink bleach to cure yourself from COVID, right? And so that's to me is kind of where I'd like to hone in on. It's kind of gonna, if you will, kind of the forensics level to establish attribution of these digitally mitigated interactions.
There's definitely a lot to unpack there. My thoughts initially, without getting too much into the legal side of things or whatnot, but the digital identities, yes, I agree, is not a correct term, and you need to find something else or just remove it altogether. But it does bring up an interesting aspect of when trying to figure out when these certain breaches happen or when these certain legal things should be triggered. Well, does it happen, say, like in a digital realm? I might have a different identity on Reddit, or a different identity on Yahoo or Google or whatnot. So do these different identities that I create need to be linked back to a real entity or something like that? And where does that responsibility come in? And when does the law say, we need to know what the real identity is behind your pseudonym on these forums, and that kind of stuff too? So a digital identity can be both a bunch of different identities, but also be linked back to who you are as an individual. But where does the separation lie? Where am I entitled to my pseudonym, and where am I required to disclose myself?
Yeah, I just chip in that it feels, so a couple of things. So try and tie it together very quickly, that we talked about property, but then we also, when you talk about property, you then think about chattel as well as a concept and what the ownership is, and therefore you go into the the old idea of like, you are the product if you're not actually paying for it on all these social medias, but it also reminds me of sovereignty, which you see in a lot of indigenous research and ethnography now, where who owns that information? They want an inalienable right to that information, so that you don't end up becoming an artifact in a museum. So I think this is the danger that we're trying to sort of navigate about, where does that entity get defined? And kind of interested in that.
Have any of you seen the Wyoming statute defining digital identity?
They try to define it, really.
They have defined it as part of their push to do. They've done a lot of great reforms for digital assets and ownership, and one of the things that they came up against was, at a certain point, we need to be able to refer to a digital identity that people are acting through, and ascribe certain acts to it and back to them as a legal person, to get to Mark's question. And it's an excellent definition. I actually helped with it. It took them about a year, and the governor signed it into law about a year ago. Personal digital identity means the intangible digital representation of, by, and for a natural person, that's a human, over which, and this is Wyoming drafting, but over which they, I would say, have principal authority and through which they intentionally communicate or act. And then there's one for organizations that's very similar. And then there's ways to attribute the acts back to a legal entity that was operating via its digital identity. And this is coming up a lot with agents and with with decentralized systems and everything they're doing with digital assets, but also with more mundane systems as well. I mean, where almost all our commerce and government and education and so much of our lives are being intermediated electronically now. Being able to have a legal primitive, as if you will, of a definition of how to refer to a digital identity is functionally very important. This one, you'll notice, Chris, completely sidesteps the question of sentience and a soul, but it does assume that there is a legal person that's operating this digital emanation, and that legal person, we presume, is sentient, has capacity, can form contracts. And so it sort of sidesteps it in a way, but it assumes it.
Well, it assumes that everybody is a psychopath, apparently, or has dissociative identity disorder, because it used a singular if you paid attention. So what they're describing is a persona. So it obviously, and that's why what I see there, and I see this on a daily basis because we reviewing these type of solutions on a daily basis, is it's a conflation of functions and use cases, right? And so that's where they get themselves into trouble. You can actually never attach those two pieces together, digital and identity per se, right? That's just a metaphor, because one is a lexicon work out of the realm of technology, and the other one is one of social sciences, right? And if and when and where we integrate maybe something like BrainGate with digital technologies, then we get closer to that. But for the time being, what they're describing is persona. So it's the data that you can control and should be controlling.
Perhaps, I mean, this is a different podcast than we should maybe have if you'd like to go delve deeper. I would have said exactly what you're saying up until quite recently, when I've become persuaded that there are products and services, and there's actual use cases, which is why this came before the legislature that they needed to solve, for which this is valid, and it's not papering over a psychopathy. It's worth, on the organizational side, taking a look at their model DAO, Decentralized Autonomous Organization, LLC,
right,
which is a legal person, and also bridges and combines some of the questions of the digital emanation versus the thing, what you were just saying, cannot be combined. So I think there's new things that are starting to evolve that we need to pay attention to. And obviously, it's early days still in terms of what is the best way to do it.
Yeah, I mean, you basically just mentioned 15 podcasts. I wrote about DAOs a very long time ago. It's one of my favorite concepts, and the idea of like corporate personhood. And so there's a lot to unpack here that would way extend what we're trying to do today. But these are concepts that I've been working on personally for a very long time, for more than a decade at this point in time. So we have a library on GitHub, and so the point of that library is to define all of these concepts in a manner that actually engineers can take that and in a meaningful way embed this into the technology. And we just had to do this as investors, because we looked at over 1,500 legal technology solutions over the past 5 years. And when you really read something like a white paper, so they're using a certain term, and you have to figure out, well, how do they actually understand that term, and then how did they implement that? And so we necessarily had to streamline that to even have a useful discussion. And so our objective here is, and we're working with about 6 or 7 organizations right now in parallel on these concepts, that we can have a shared taxonomy and then also a shared topology on that. We can break that down so that these systems will be over time interoperable with the legacy system, because that's something that's largely overlooked by teams that we are looking at. There's an existing framework. Obviously, there's data being exchanged on a daily basis that you cannot really disrupt without creating real-world externalities. And so that it's true for all the big legacy network systems like banking and travel and telecommunication. But the larger point there being is, so over the next couple of years, we'll establish a taxonomy that holds up in this intersection of legal and computing to affect real world economic activity at scale. And so I can make a couple of examples because otherwise it sounds too obscure. So UCI just started a legal clinic where they implement this specifically for one particular use case, so getting a restraining order. And so right now, when women usually submit a restraining order, 80% of them being rejected because they simply don't know that vocabulary, they simply don't know what boxes to check. So it has a real world effect, right? And so creating these use cases affecting these technologies has immediate real world effect, and in this case on a very particular group of people. But that's very important to me because I see hundreds of solutions every week, every month, and most of them I would consider non-viable because they don't understand these concepts, right? I'll make one particular example and then I stop my typical rant. By and large, people have not understood the principle that Bitcoin introduced, which is simply that you can have ownership rights to your own bytes. And so, but what that means is also that you can actually never commit any data to an immutable public record. So to everybody on the call here, that should be obvious because now you cannot no longer comply with certain laws and regulation, right? But from an investor's perspective, it simply makes your application, whatever that is, a dApp, a decentralized app for influencing real world economic activity, it makes it uninvestable, right? So that's why outside of the human aspect, obviously, that's why we care about that. It's like, please understand these concepts because in most cases what people are doing there, what we kind of internally coined this term, you're invalidating the necessary herd immunity of that particular chain if you're creating this immutable record, right? Again, you always have to stop me. I can keep on, because I have a lot of pent-up energy. I've been talking and writing about these concepts for more than a decade. I'm just so excited that I finally have people that listen to it, and actually people by and large are understanding it and the importance of it.
The DAO side of things I find very interesting because the US SEC kind of, I think, set a precedence when they came down on a few DAO organizations, especially the decentralized exchanges, and said that, you know, the authors or the code writers behind the decentralized exchange are the ones that are responsible for the decentralized exchange. Therefore, they are the ones responsible for the financial transactions, et cetera, and all the securities compliance that goes with it. So, yeah, I find that.
Well, that comes back to what I said earlier. That is either an ignorant or deliberate conflation of function and use cases. It always comes back to the very simple example of a hammer, right? So the function of a hammer is simply to centralize centrifugal force, and the default use case is to put a nail in the wall. If I use that particular hammer to bash someone's head in, I didn't change the function of the hammer whatsoever, right? So you're talking about technologies and you're conflating it and you're trying to conflate two other topics because regulators keep saying things like we're making law. They don't make laws, right? That's very important to understand. Unless they are God, they do or have godlike powers, they don't make laws, they make rules, right? So laws are things that are have a consequence regardless of the nation state's enforcement, right? It's just the fact that they're forgetting that, well, you're still subject to the rest of the laws of physics and an externality of physics as technology. So the technology is trying to affect physics, and then people engage with these technologies. So, and it's a very, I think oftentimes it's kind of used for propaganda purposes, as in people will say nonsense stuff like, I'm going to outlaw voice over IP was a very prominent statement back in the 90s. I was very heavily engaged with that. And to this day, some countries claim that they outlaw voice over IP. Obviously, it's a nonsense statement, right? Voice over IP exists, it cannot be uninvented. And what these countries are actually saying, these regulators are actually saying, I don't want you, citizens within my jurisdictions that follow my rules, to engage with these particular technologies in a particular way, right? And this is true for all technologies. So, but it's important to understand these differences, right? Because we're getting into the position where we're creating law using technologies, kind of the old adage of code is law, which is both good and bad, right? So again, technology is neutral. The hammer is neutral. The bytes are neutral. That's why also trying to put these labels on bytes is kind of exercise in futility. We have all these discussions. People try to drag me into those every day that amount to a discussion around the color of bytes, i.e. should I call a certain set of bytes a utility token or a currency? That's nonsense, because the only person that would know that is the person that is moving control over that set of bytes. That's it. I can send Bitcoin to a null address. I can summon ETH to run a dApp. No one can actually make the legal decision before that particular entity engages with that technology, just like you cannot make that legal decision. Well, you touched a hammer. You wanted to kill someone. No, that's not how hammers work. That's not how standardized smart contracts works. That's not how any technology works. It's very infuriating because, again, I don't ever want to assign malice when ignorance will do, but there's a lot of ignorance out there in the context of technology that we need to be careful about, because a lot of people engage with that on what I would call the level of the problem where it was created. End of rant. We should have like a timer that starts ticking whenever I start to rant. So like, Chris, you're nearing your 99-second allotment for your 4 rants that you get per episode.
Well, we are overtime, and I appreciate people staying a little bit long here. But this has been a really excellent conversation, and we went a lot of different places. But the focus really was on sensitive information. And I think we got to some interesting places. Appreciate all the guests here, Dazza, Mark, and Michael, as well as my co-host Chris. This has been episode 17 of Your Bytes, Your Rights. Appreciate your attendance, and we hope you're here again next week. Thanks, and have a great weekend.
Take care, everybody.